use all our precious time to explain where the legislative process of the European Union is heading to. So first of all, I would like to thank the European Commission both for funding our project and for being present here, highly represented by officers in charge of driving the proposal for directive through the difficult legislative process. And I would also like to thank all the researchers and judges, professionals, advisors, bank executives that dedicated part of their scarce time to our project. Many times, asking for interviews, we said we need 1 hour, 1 hour 15 of your time, but we were lying clearly. We knew that we are lying, and none of the interviews lasted less than 2 hours, but none of them complained. And actually, most of them thanked us for asking questions, which is quite funny, but it happened. I also like to thank the Center for European Policy Studies for generously hosting us here and making our conference possible. So I'd like immediately to give the floor to Mihaela Carpus Carcea. Many of us know her directly, and all of us know her because she's the officer in charge of the legislative process, and I'd like her to tell us what's going on in these hours while we speak. Thank you, Mihaela.
Thank you very much, Lorenzo. Good morning, everybody. Well, I do have a very personal relationship with many people in this room because we've worked together in an expert group preparing the Commission proposal for a directive in the area of restructuring and second chance. It's a pleasure for me to see you again, and it's also a pleasure to be able to update everybody on what's going on with this proposal, which is already 1.5 years old. So as you can see, and that's maybe a disappointment, but probably not a surprise, the legislative process is quite slow. However, from the inside, I can tell you that even if it appears slow, we don't have enough time to process all the information, all the concerns being raised, all the new research that is being done on this topic. So we appreciate very much the work you have done, and we will try to use it the best we can. Of course, but it's a pity that today, for example, not many member states could attend. That would have been really, really helpful, I think. So I want to thank you for having us here, and I want to thank you for the work you are doing. It's going to be very useful. From what I have seen, it already confirms in quite a few instances, the direction that amendments are going into in the Council. I could not say the same for the European Parliament, the report of which will be soon made public. It appears that in the European Parliament the concerns are a bit different than in the Council, and certainly than in the research you have conducted. But we'll get there. It's a long process, but usually the outcome is, as every compromise, a moderate improvement, let's say, on which we can build in the future. So where we are currently, it's weird, but or maybe weird, but we are basically about 8 months away from the end of the work in the European Parliament, and that's how we are thinking. We have 8 more months, basically, to have a political agreement between the Council and the European Parliament, and working backwards, we are about 4 months away from having a general approach in the Council, so basically an agreement between the member states. we need to achieve these milestones in order to have the adoption of this proposal before the end of this European Parliament's mandate. And that is a constraint which is useful because it focuses the minds of people. Everybody is in agreement that we should now really step up our work and finalize this project, because with a new parliament, everything can start almost from zero. A lot of time is wasted because we need to wait for the new MEPs to come, to set up their committees, to nominate new rapporteurs and so on. So everybody in the council, in the parliament, in the commission is really committed to finalizing this project as soon as possible, and certainly to have a political agreement is what we call the agreement between the council and the parliament by early spring next year. So this is like in the big picture of the negotiations, but to go in a bit more detail, the parliament, as I said, has already made their position, have already taken their position. In the council, we are still working on the details. The work in the council is a bit more technical in that they really look at every word and every comma, and they try to figure out what the impact will be in national laws. So that's why it's taking a bit longer. Today, for example, we have a meeting. We started yesterday, but today we continue the discussion on, among others, the article on the cross-class crackdown, which is a very important innovation in our proposal. Many member states do not have such a mechanism in preventive restructuring proceedings. Well, member states, some of them don't even have preventive restructuring proceedings in the first place. So it's really amazing that they have all agreed last December that this cross-class crackdown is useful to have. But now we need to figure out the details of how this could be implemented in order to be efficient on the one hand, but also fair and equitable to all parties. So we need to discuss the details, and I've seen that you have made some proposals in respect of how that article could be improved. What I can tell you is that there is a feeling in the council that indeed the commission proposal was a bit too rigid, a bit too strict, and it will be changed, hopefully not fundamentally, but it will in the end perhaps achieve a fairer result for all creditors. We'll have to see. Certainly, I will try to bring into the discussion the results of your study. I think it would help, because we see that the direction in which the discussion is going is quite similar. The other topics which we will discuss today are, for example, the position of equity holders. Again, very sensitive issue, especially if we are talking about small enterprises. I think there's where perhaps many of the amendments which will be made in the Commission proposal are really changing a lot on substance. And then the articles on the adoption and confirmation of the restructuring plans, those are also on the table for today. We'll see how far we get in our discussions. I know I have a few more minutes, but if you would agree, I would stop here in my very general presentation, because I'm not allowed to tell you a lot from what is going on in the council. That's still confidential. Perhaps. Yes, but then I saw this is web streamed. No, but what I would propose is that perhaps we give the floor to participants to ask questions, and in reply to questions, perhaps I'm forced to tell you.
I'm sure that just a question of how many questions you can take.
Until 9:20, so.
Yeah. Nico Tollenaar, one of our speakers.
Yeah, Mihaela, could you tell us a little bit about the key proposals that we might be seeing coming out of the European Parliament that depart from the current draft?
Well, probably you have seen the many amendments that were tabled by MEPs. Some of them were very contradictory. So in the end, the final report will have one position, probably something in the middle most of the time. But it's true that what we have noticed and what I have the feeling will be there in the report is concern with the protection of workers in restructuring proceedings. And it may not be our position that workers need to be protected in that particular way in restructuring. That's why we haven't proposed extensive new measures on worker protection, even though we did have a few provisions on that. So we will see exactly what the compromise amendments will tell us on worker protection, but that was one of the major concerns, and is still in the European Parliament. The other one is the protection of creditors. So we see another group of amendments which will try to give creditors a bit more protection. Again, for us, it would be good, of course, if the amendments were sticking as close as possible to our to our initial proposal. So some of these amendments we can salute. For example, the duration of the stay, because we see the discussion in Council, going a bit in the similar direction. And if the positions of Council and Parliament are close enough, that means that we won't have, blockages in what we call trilogues, so later negotiations between Council, Parliament, and the Commission. I can't go in too much detail, but the report, I think, will be published quite soon, so we will see very clearly the amendments that are made.
European Banking Federation.
Doesn't matter, I can show Thank you very much.
It's important.
Okay, thank you very much. Hey, Mihaela. My question is, the Commission's original proposal lacked any definition or test of viability, and also provided ability for illiquid debtors to access the stay. That's Article 7.1 I'm referring to. My question, are there discussions in the Council basically addressing these issues, or how do you see it? Would you support any as Commission, or would you still stick to your original language without any viability test and allowing illiquid debtors to basically burn remaining cash? Thank you.
First of all, we were not against a viability test in the beginning, but the reality is that you see, member states being split on the idea of viability. Perhaps, roughly half of the member states have a viability test, but in each of these, the viability test is different. And about half of the other member states do not have a viability test. So what we proposed originally, but I'll tell you already that we've moved on from that position. Originally, we proposed that there is a very light test, so that, for example, the stay is granted if and to the extent that is necessary in all member states. That was not accepted because, member states which have a viability test wanted something more, and those which do not have wanted less. So in the end, we would probably end up in a situation where there will be an option for member states to put in place a viability test, but not an obligation. And we can agree with this. It departs from our original proposal, but you know, in the spirit of compromise, we would probably agree with such an amendment. It's already public knowledge that under the Estonian presidency, the Justice and Home Affairs Council has agreed with this position. So if you're curious to look into the viability test, it's already public, basically. So the other question you had was on illiquid debtors. And you know, the tests of insolvency are very different in the member states. Some use illiquidity as a test, some use over-indebtedness. We didn't want to go into that discussion because although we are convinced illiquidity is the good test, we could see it would be very difficult to get an agreement, a harmonized rule. What we then decided to do was to try to protect restructuring proceedings in cases where the debtor might become insolvent under national law but is not yet illiquid. So we, in Article 7, which you brought up, we said that the state should suspend the duty to file of debtors and any insolvency proceedings which are open to the request of creditors, but that member states can derogate from that rule where debtors are illiquid, so not over-indebted. And because otherwise, you know, the whole idea of early restructuring would be undermined. So that doesn't mean to say that we support the restructuring of illiquid debtors. We actually have, you know, this whole preventive restructuring procedure is defined as something aimed at avoiding insolvency. So clearly you shouldn't be insolvent as a debtor when you start this proceeding, but we don't want to stop member states from making these procedures available also to insolvent debtors. It happens in countries which are very highly ranked in the World Bank index, where the rights of secured creditors are measured, or the recovery rates for secured creditors are measured. So we can't have a valid claim to tell to member states you should limit preventive restructuring only to insolvent debtors. But it is our position that at least our directive, the scope of our directive is limited to situations where the debtor is not yet insolvent according to national law.
Professor Irit Mevorach.
Thank you. Good morning. Good morning, Mihaela, and thank you for the... You can't hear?
Yeah, yeah, we can.
So thank you for the explanation about where we are. That's a question which is kind of technical, or to understand the process and what we can expect that maybe happen between now and the spring, or that can happen. For example, following this kind of extensive research, are we expecting only, or can we expect only amendments, tweaking, changing of the existing directive, or is it possible, and I'm thinking especially about SMEs, the small enterprises that I think the directive aimed to cover, but if there will be, for example, a conviction that you need a bit more specific procedures for them, maybe even a part, maybe even a chapter devoted to the small enterprises. Is it at all realistically feasible to consider that between now and the spring, not only amending existing directive provisions, but do a bit more than that? Is it at all possible?
If I may add one word, one of the findings of our research is that restructuring is mainly designed for large business, and so our fear is that the entire pool of European small business will be de facto cut out from accessing this instrument. That's why there's some proposals coming from this research that aim at simplify or radically change some parameters to allow restructuring for SMEs.
There's a language for a proposal for a few articles to be included in the
I don't know exactly what is your expectation, but for sure there will be some amendments which will take into account the situation of SMEs, let's say, better than the Commission proposal has done. Probably not a chapter. That it's too late in the negotiations to table anything as significant as a new chapter. But you might see, for example, certain derogations from certain rules for SMEs. For example, I'm not sure this would be agreeable to everybody, but the class formation was considered to be too complex and expensive for SMEs. So you might see a rule saying, well, the class formation shall be optional for SMEs, in the sense that they could make recourse to it if the situation requires, but they shall not be obliged to do it. And you might see similar rules in other places of the proposal, but at this stage, it's very, very hard to introduce completely new topics for discussion in the Council. The tendency is more to simplify what we have than to add even more rules. Yeah, but you will see. For SMEs, you will definitely see a few improvements.
Time for one last question?
Yes, one last.
Well, it intimated the question I was going to make, but just as a follow-up very quickly, but the directive needs to respond to the needs of 97% of the businesses. And this is our finding, and I think this is non-controversial. So the directive will be all too well and great, but if it doesn't tackle the main issue, then it's only going to be partially. So we understand from a political point of view, it might be too late, but it's also a shame that now that change has come finally, 97% of the users, potential users of the system, will be left out. But in any case, my quick question was very quick. If the Commission is going to have a final proposal in which there is there are many options, option A, option B, such as the one with the stay, wouldn't that do away with one of the objectives of the directive, which was to prevent forum shopping? Not that I'm against forum shopping. If it's good forum shopping, it can work very well. But if we are allowing so much difference between the member states, for example, something as important as the stay, that might undermine the weight of the final outcome, perhaps.
Yes. Well, we completely agree that less divergence is a good thing. In our proposal, we have tried to limit the divergence between member states while being conscious that we need an agreement between them. So we could not, for example, impose maximum 12 months stay period on countries where even 3 months seems a lot to ask. So being aware of the realities, the best we can do is to try to correct the extremes, essentially, if we speak about the stay period. Now, we may succeed in that. We may achieve something more or less ambitious. The question is, what is preferable, having nothing or having something which is an improvement and which could be later on further improved? That's in respect of your question on differences. So we will reduce some differences, but many will still remain, because we don't want to spend 20 years negotiating an instrument with possibly the same result in the end. The question on SMEs, we had very much SMEs as a concern when we drafted this directive, and we have tried to foresee a procedure where the more complex the restructuring, the more tools become available. For example, we don't think cross-class cram-down would really be of use for a lot of SMEs, but still it's there. We didn't limit the scope of that rule to large companies, although there are voices who request that, but our position is that it should be available. Who knows? I mean, there may be an SME which might need it and which might be able to use that mechanism. But it's true that, you know, as some of the rules, for example, also on valuation, which is somewhat connected with the cross-class cram-down, will not be useful for SMEs. It doesn't mean that they have to use them or that they will ever actually need to use those rules. I think the question is how much SMEs could still make use of this procedure, and we heard a very interesting presentation from Daniel Fritz in Varna a couple of weeks ago, and he was explaining that in Germany there was a procedure introduced. It's not really a preventive restructuring, but it's quite similar. And at the beginning, it was used only by large companies. But as insolvency practitioners became more expert in the procedure, and as they were using it more, there is an increasing trend of SMEs starting to use that procedure. So it might be that initially this would be used by large companies because probably they will also have the funds to test these new procedures. But in time, the benefits will trickle down to smaller companies as well.
I think that we used all your time and even more than originally planned. And thank you very much, Mihaela. We wait for you to be back for the lunchtime panel. And thank you.
I'll be here. Thank you very much, and have a very good conference.
Thank you. Okay, so the conference goes on with introduction to the project and main results. Again, thank you for being here in what is obviously a busy time of your year, and we'll try to keep your attention as high as possible by staying with hard data. First of all, I would like to thank the researcher and researchers, the project coordinators like Christoph, Paulus, Riz, Mokal, and Ignacio, and saying that it has been a big honor to coordinate this project. And I can't say it's always been a pleasure to coordinate because it has been very hard at the time, but in the end we are happy that we are able to share the results with you today. First of all, where we started from. Everywhere in the member states, in European member states, there's a clear trend towards contractual solution of business distress, which is perceived as more efficient than traditional insolvency procedure on which their legislation has rested for hundreds of years. But what happens usually is that the law opens up spaces and takes stakeholders in uncharted waters. What does mean? What does agreeing on distress mean? This is not written in the law. The law just allows stakeholders to contract out of distress, doesn't say how to contract out of distress. And what happened is that the law cannot, and I would say should not, fill the void that is created by the enabling provisions that allow contracting out of distress. The consequence is that costs and risk may arise, and we have seen this as a real risk. For instance, I can I cite the example I know best, which is Italy, which in 2005 took a bold move towards enabling contractual resolution of distress, and with this further step until 2012, that was basically the main driver of legislation. And then since 2013 is now going in the opposite direction of the, the pendulum. The pendulum is moving towards more judicial intervention. And if law will be approved, then I think that we will be very much backward. What we think is that this void must be filled by best practices, by identifying what is considered to be a best practice for drafting plans, for drafting fair plans, high quality plans, for negotiating with creditors, and for confirming and supervising the implementation of plans. The practice has a large experience of good and bad plans, and our research aims at identifying what are good plans, good restructuring, and to highlight them as good example to follow. In 2015, the DG Just issued a call for grant aiming at identifying best practices for judicial supervision of law involvement, with procedures with law involvement of judges. The approach we took, and I have to thank our project leaders, is to go through a phase 1, which is qualitative and quantitative empirical research in 4 jurisdictions, Italy, Germany, Spain, and the UK, done with thousands of court files and hundreds of interviews and questionnaires targeted to specific professionals, advisors, bank executives, and so on. And then phase 2, which was mainly done this year, drafting common guidelines. During the implementation of the project, the Commission issued the proposal for the well-known proposal for directive that Mihaela has just spoken about, and this increased the relevance of the project. So we decided to split the output in 2. On one side, guidelines to stakeholders, and the other side, policy recommendations to either the EU legislator and the national member states legislator, aiming at solving what we have perceived as the main problems of the practice. The research team is University of Florence, Humboldt Universität zu Berlin with Christoph Paulus. University of Florence, I have to say, this is a real honor, is associated with Rismo Cal. Universidad Autónoma de Madrid with Ignacio Tirado, and several associate partners, Consejo General del Poder Judicial, Banca d'Italia, and Entrepreneurship Lab Research Center. I want to thank all of them and many researchers, and some of them volunteers. I would like also to thank particularly a person, Wolfgang Zenker from the University of Berlin, that helped us through the project with incredibly valuable insight, and that could not make it today. The main results are, I would say, main results are 5. I could speak for hours, but that would be terrible. And I try to summarize 5 areas without prejudice of all the discussion that will take place, thanks to our speakers and panelists that are incredibly well qualified, and we are grateful to them for having accepted. Restructuring is a complex endeavor, and we think that needs some court involvement. And particularly the UK research has shown that something that we all think is there. Restructuring may have externalities, and externalities to non-participating parties, and particularly with the debtor, if creditors are abusing the debtor, secured creditors are abusing the debtor, and very often debtor and secured creditors abusing the third parties and unsecured creditors. Leaving to the parties may lead to unwanted results, and that's why we believe we need judges as referees, not as players, as our member states. In our many member states, they perceive themselves, parties perceive the judges to be. Second point, the risk of abuse is real. Either is real because, as in Italy, the fear of abuse has driven a legislative process backward from contractual resolution of distress, either legislative process and, I would say, judicial attitude towards restructuring attempts. And in Germany, if the interviews that our team has done in Germany has shown that there is a big fear of abuse of these restructuring tools. So what we think is that diffuse confidence in the integrity of the system is needed, which in practice means clear principles on what are the goals and anti-abuse provisions written in the hard law. Third finding, which is not necessarily favorable, restructuring is mainly for large business, and in part this is the product of the cost. Restructuring is a costly affair and needs costly professionals and advisors, and these costs are manageable only when asset value is sufficiently high. But there are also other conditions that must be met. Timely access, which is a huge problem, we'll see later. Debt concentration, the less banks, the more successful is the attempt to restructure, and reliable accounting and monitor systems, which brings us to the conclusion that probably for SMEs there's not much that traditional rules can do. Therefore, the proposal of our team to introduce special rules, not to allow bad quality, low quality restructuring for SMEs, but at least to simplify some rules to reduce costs. We have to add something, that the bank rules on non-performing loans may compound the problem, and the emergence of credit servicer for NPLs may change the rules of the game. This is something that I know some of the participants would like to raise the attention. Debt for equity swaps are extremely rare. We have seen very few cases, or at least very few cases except for large businesses. The fourth, and I would say very robust result, is that access to restructuring is usually not timely at all. This is very intuitive. We know that the earlier the filing, the better the outcome. We have seen evidence in our quantitative research that the shorter the time between the first sign of distress emerging from the risk system of banks, and the more successful is the plan and the higher the recovery for creditors. Stigma of failure is still perceived as high. Spain, Italy, and Germany have different systems, different traditions, somewhat different traditions. And everywhere, professionals advise against going to court, or at least they register the fact that they don't want to go to court. A duty to file does not seem to solve the problem, and the key trigger is liquidity. The debtor very often doesn't go to court, doesn't tackle the problem unless it's illiquid. One of the problem and the findings is that concentrated ownership, and especially family ownership, is an obstacle. Family has a high stake in the business, and of course, for many reasons, either personal guarantees and both personal guarantees and the investment in the firm, the family don't want to go to court, and they prefer postpone their solution of distress. We hope the directive can do much in this direction, but of course it will not be a magic wand to solve this problem. And even last point, professional costs that arise as exactly in the verge of distress may be a challenge. Fifth and final point, restructuring often does not lead to complete recovery. We have seen many times that there are multiple rounds of restructuring, outright failures after restructuring. What implications should we draw from this evidence? There are two possibilities. One is that probably both conclusions are true. On one hand, there are bad cases that are not sufficiently filtered by professionals and by courts. And in other cases, we believe that this is simply the consequence of the fact that the future is always uncertain. So very often the plan is a bet that the parties take. They might win, they might lose, but the fact that there is uncertainty does not warrant the not taking the bet. For a clear example, I would like you to draw your attention to chapter 4, footnote 28, where we commented the case in which Italian courts required certainty, absolute certainty of a future event, and the consequence was that they did not admit the debtor to a judicial composition with creditors. And we believe that taking this position to the extreme, this is a chance wasted. Final consideration, we are now at an important junction. Mihaela told us that in a few months, the member states will be put in front of their responsibilities to implement the directive. And we should not waste this opportunity, and we believe this is our approach. Maybe we are wrong, but we hope not. Best practices can serve an important role to fill that gap that the law has created or will create in member states' legislation in the coming years. We need highly trained and specialized judges, and some of them are here, and we thank for being here, and we hope more of them will be assisting us in the future. Thank you. Ignacio?
Just a very quick clarification on 2 points.
The microphone?
In the air. When Lorenzo spoke about debt concentration, and he said the fewer banks, the higher the likelihood of restructuring, I believe what the result offers is, of the research, is that fewer banks as opposed to many banks, but not fewer banks as opposed to having a lot of other types of creditors.
Absolutely.
So
Thank you.
It's easier if we have 2 banks than if we have 10 banks, but we definitely need a debt concentration on the banking sector, otherwise the restructuring will not fly. So and linked with that, and with the stigma, in some countries, at least in my own, stigma is important and reputational damage is important, but the main reason why in-court proceedings and formal proceedings are tried to be avoided completely especially by repeat players and by banks, is the possibility to lose control of the restructuring process. So once it gets into court, it's out of their hands, out of their control. They don't know how, they can't predict, therefore they're not willing to provide additional financing. So is the loss of control that they fear, not so much the reputational damage of the debtor. So just to to add to the conclusion in that sense.
Thank you, Ignacio, for clarifying this. Now, we now give the floor to the first panel, and Christoph will